So we're looking at Rule 803.18, which looks at learned treatises and the beyond sort of the procedure of how you go about getting aspects of a learned treatise admitted. We're also going to talk about the subject matter of that and the manner of presenting this to the jury. So in the Paulos versus Covenant Transport case, we're looking at the question of when a truck driver passed on a mountain road in Utah. The question was, how should he have reacted? Should he have slowed down and moved to the right as the car was attempting to pass him? And of course, a terrible tragedy ensued as a result of him not doing so. And so in the course of the trial, there's an expert who testifies that, in fact, he should have slowed down and moved to the right. And while the expert was testifying, he made reference to a book on safety for truckers. And the question then was, could that book or the portion of the book be admitted to the jury? Could the jury hear what's in this book on traffic safety? And at the time, the plaintiff had tried to get the book in as just a manual for the operation of trucks that any driver should have relied upon, and the defense argued, first of all, it shouldn't come in at all because it doesn't fit any exception that would qualify under, and if it fits anything, it's 803.18, the exception for learned treatises, and under that exception, the reason that they would even bring this up is under that exception, you don't send that publication to the jury, as you would say, as we just learned with 803.17, with market reports. The jury actually can take that back to the deliberation room. So the defense, A, doesn't want the jury to hear at all what's in this traffic manual. But then B, if the jury does hear about it, the defense doesn't want the jury poring over the book in the deliberation room. The defense wants the jury just to hear it as little as possible, as little attention drawn to it as possible. And so the defense argues that, look, if this is anything, it's a learned treatise, because the learned treatise can only be read to the jury. The relevant portions can be read, but it's not like they take this massive book back and can, examine it and such. And so the court holds that, yes, this is in fact a learned treatise. And the threshold question there is like, what does learned treatise mean? And so, you tend to think of this as like, a book on Gray's Anatomy is the kind of the standard book that's often offered in malpractice cases to establish, where something was on the body, where the spleen is located, for instance. So Gray's Anatomy is kind of your textbook example of a learned treatise that would be offered in a case. And so the defense argues, look, this book on traffic safety, this is not a learned treatise. This doesn't seem like Gray's Anatomy. This doesn't seem like a treatise on physics or on even like art, for instance. You could imagine like a book that offered the history of French Impressionists, for instance. That in essence it was sort of a snobbish argument that the defense was making, that traffic safety isn't as sophisticated of an academic discipline as, say, medicine or science or art. And so the court says, no, absolutely not. That's not the case. That there are many federal cases. This is a Utah case. No Utah case has found traffic safety to be something that's admissible as a learned treatise. But there's plenty of federal cases that have. And the court says we look to those as analogous. And so it does come in. And the other thing to note, though, is unlike, say, a market report, when we were looking at the NADA Blue Book in the Batiste case, in that case, the prosecution was simply able to offer the Blue Book to the jury itself. There didn't have to be any kind of qualifying witness who spoke to it. For a learned treatise to be admissible, it has to be something that is brought to the attention of an expert witness on the stand. You couldn't just bring in Gray's Anatomy and say to the jury, you all know what this is, and here on page 472, that's where the spleen was supposed to be, where the doctor didn't find, for instance. So the court in this case says that yes, this is in fact a learned treatise. It fits the criteria, and that means two things. Two things procedurally. One is the expert has to refer to it. So the expert has to say, yes, this is a learned treatise, and yes, what you're saying there contextually makes sense in this case. That is what we're talking about. What the author has said is relevant to what we're saying here. And then it is simply read. They don't take Gray's Anatomy back to the jury. So that's 803.18, learned treatise.